in the matter of Last Bus Ltd, TA Dublin Coach, and Dawsongroup Bus and Coach Limited and another.
Yes, Mr. James.
My Lords, good morning. I appear in this appeal with Mr. Roundtree. Mr. Benzie is on the other side, as you know. We've arranged to be in the same row.
That's very much in accordance with my preference.
I'm very good. Thank you. Lord, I'm going to start with some opening remarks, and I'm not going to be hugely long in opening remarks, and I'm going to get into 3 chapters. But this is an appeal which carries, if I may say so, by the standards of this court, a very small amount of paperwork. You'll be pleased to know that I don't propose to walk you through the skeleton. It's take it as read, and the content of it is read. And I think the key issues can be submitted in reasonably short order, and I propose to do that under the following 3 chapter headings. First of all, a short introduction. Secondly, a walk through the authorities. Now, I don't normally do that, but here it seems to me, I would submit, helpful for the court to see them as they have evolved and to see what they tell us and what conclusions can be properly drawn from them. And I want to do that not only for that reason, but also I'm going to submit with great respect that the judge erred in one of his conclusions about the leading case of Purnell. That was Vice-Chancellor Nichols' case. With respect, I'm going to submit I don't think he got the answer to that quite right. And he's placed inappropriate weight, we say, on the 3 cases relied on by the respondent. That's the 3 Court of Appeal cases said to assist with the current trend. And that's one of the reasons I want your lordships to see these authorities in their order. Finally, chapter 3 will be an analysis of the judge's approach and his judgment to demonstrate why the appeal should succeed. But I'm hoping that can be taken pretty swiftly, because by that stage your lordships will know obviously what this is all about. So chapter 1, introductory remarks, please, first. So I know I don't have to say this, but forgive me for doing it. The facts have to be assumed in my favour,
yes,
because we've come here on a summary judgment. Accordingly, the case proceeds for now on what I would respectfully submit as the following basis. My client ran and operated a high-quality public service coach company and purchased 30 coaches designed and manufactured by Mercedes, which were marketed to him as worthy successors to the earlier model that he had purchased from them, but which had had to be updated to comply with new European emissions standards. Point 2, Mercedes manufactured and sold this coach when it suffered from a major design fault which caused it to catch fire in service. Your lordships will know that that isn't just a pleading assertion. We've also outed, long before any direction requiring to do, we served an expert report supporting that. Your lordship's not being asked to form a view on it, but it just bears statement that it is currently supported by an expert. Point 3. EvoBus, the second defendant, imported and marketed the coaches with that defect, but without saying anything about that defect, and then sold them to Dawson, D1, a finance company with a specialist coach hire division. And Dawson bought them so that they could provide them on hire purchase terms at profit to Last Bus or Dublin Coach, according to one's preference for their name. Point 4, the claimant took them on hire purchase, believing them to be safe and properly designed, and was then, after 4 of them caught fire, as described, was obliged to institute and maintain a very expensive and completely unforeseen maintenance program in order to accommodate or keep under suppression that design fault. and this costs significant additional expenditure and loss of profits. So those are, we say, the facts that in broad terms must be assumed. The claimant has sued the supplier, D2, and the hire purchase company, D1. While it's not before you, there are Part 20 proceedings between them, currently stayed, because of this summary judgment and appeal. Because, of course, just as the claimant is a purchaser from the hirer is a purchaser from D2.
Do we have that purchase contract?
Lord, I didn't hear, I'm so sorry.
Do we have that purchase contract?
We don't. Lord, I'm not sure I've seen it, the contract between them. As I say, Part 20 proceedings have stayed. I don't know their current status. So I don't myself know precisely what state that has reached.
But Dawson hasn't disclosed it in this part of the claim.
No, don't think so. I will be reminded if I'm wrong about that, but it's not a document that we've got.
But we plainly have a tripartite,
Yes.
not necessarily, it's not contractually tripartite, but it is, but there's a tripartite arrangement, and we do not have sight of one limb of that
Correct.
arrangement.
One of the points that I'm going to make to your Lordship, and we've made it clearly in the skeleton, is that taking this summary decision in isolation from the claimant's claim against D2, we say is an error. But I'm also going to say here that that error is compounded because one isn't going to know the full picture until we get to trial, if that is what happens. And we see then what the Lordship would describe as all three sides of that triangle. So we would then be able to see what was, I'm going to call it conventionally, the collateral position between C and D2, the supplier, the direct sale and purchase position between the supplier and the hire purchase company, and then, as your Lordship has before you, and you already know, the position between the hire purchase company and the claimant.
We haven't got the defence of the second defendants, at least not in the court bundle. But what's your cause of action against them?
The defence against the second defendant, we say we have a collateral contract against them, a contract which still exists. They say no, there's no agreement with them, and if there is, it's got an exclusion clause in it. In short order, that's the position.
The exclusion clause we see in the bundle.
No, they've got their own exclusion clause in it. In other words, as the trial, I say the trial judge, the learned judge below rightly pointed out, I could well end up in an active reasonableness argument with D2.
Well,
So
we have the new vehicle order form. Is that the one you're referring to?
I think your Lordship.
Supplemental bundle, page 157, exclusion of liability.
Let me just check if I'm being correct in my. So that is the yes. I'm sorry. We do have that document in the bundle. You're quite right.
Supplemental bundle, page 155, is the new vehicle order form, or one of them presumably. And the exclusion clause is at 157. Clause 10, is that the one?
Yes, Lord, you're absolutely right. And this is the document I think was referred to in the judgment of Justice Andrew Baker, at least in passing.
On the face of it, whether it's reasonable for Dawson to exclude liability, you would think would at least in part depend upon what their contractual terms with the supplier are.
Yes.
Because if they have a right to bring a back-to-back claim, it would be monstrously unreasonable for them to completely exclude liability when they effectively have a straight, and they can just simply sit in the middle and pass the claim on, and they will do that anyway, presumably. Which is,
if I'm being honest, and not giving evidence, what we assumed would happen. So the way in which this has progressed so far was a surprise to us. Mr. Justice Andrew Baker took the decision he took. We're attempting to overturn that. But it seemed to us, on conventional grounds, the way in which this dispute needs to be resolved is in one of the two ways that every other dispute which is referred to in the authorities bundle before you has been resolved. The one of two ways are a full trial or the trial of a preliminary issue. One of the points I'm going to make is that there is no case before you in which the step change has been undertaken of making this decision on one side of a triangular arrangement summarily. That there is no summary judgment case that I know of, certainly not that's come on appeal.
So you certainly wouldn't, I wouldn't need much persuasion that certainly there's a general, my understanding in practice and on the bench has been that the question of UCTA unreasonableness is prima facie a matter that is determined at trial.
Yes.
And I entirely agree with you that it may often be by way of a preliminary issue, but it seems counterintuitive that that issue would be determined on a summary basis, unless it is said, and it may be said here, that there is absolutely no other material which is potentially relevant. But here you've already identified, or we've already identified in our discussion,
yes,
it might be useful to see what Dawson's rights were against EvoBus.
Indeed. And my Lord, I'm going to be taking you in due course to the way in which Mr. Justice Andrew Baker dealt with that, because that was unsurprisingly a matter I spent quite a long time on, trying to persuade him that he could not, in fairness, consider the isolated summary judgment evidence, calling it that, in writing, in the absence of that wider picture. Now, as it turned out, I failed in that endeavour, but I can't help thinking that the way in which the judge has approached it, and there's an echo of it in his judgment when I take you to the two relevant paragraphs, is to approach it on this basis, that if I can vindicate my claim against D2, then I don't need a claim against D1 and they can justifiably exclude me. And if I can't get a claim home against D2, then I can't, on authority and logic, seek a better position against the higher. When your lordship comes to see what is said, I hope that I have not overstated it. I'm pretty sure I have not. It's the theme, and it was the theme.
That's assuming there's a contract with D2.
Pardon?
That would be assuming there's a contract with D2.
Well, his. I think what he decided was this: that if I had rights against D2, then I could pursue them, and if I didn't, it was the claimant's own fault, and I couldn't get myself into a better position against D1. Now, there is a passage in Purnell, which I'll take you to, which does put the proposition that it would be difficult to see how you could be in a better position against the hire purchase company than you could be against the manufacturer or supplier. But it's not that's not an absolute position, but it is a general
But that means if you had bought, you can't be in a better position against the hire purchase company than you would be if you had bought from the supplier.
Correct. Correct. So what it says is, well, if that's right, the next logical step is that if you've got a claim against D2, you don't need D1. If you haven't got a claim against D2, you can't do better against D1 because you've got 0.
But that ducks the cause of action issue, which I raised. Can I just pick up a phrase you used a few minutes ago, Ms. Jones? You said a possibility might have been the trial of a preliminary issue, but wouldn't that depend on what the preliminary issue was? I mean, the preliminary issue of whether the exclusion clause in clause 5B of the contract between you and Mr. Benz's clients is in effect what Mr. Justice Andrew Baker was deciding, albeit on a summary judgment basis. But speaking for myself, it wouldn't be any use having that as a preliminary issue, you're saying in effect that at least liability, never mind quantum, but at least liability should be determined at a trial with all three parties present.
What if I indicated anything else I didn't mean to? So my starting point is this is a holistic exercise, if you like, we'll give that expression, where we have three parties, and I'm suing two of them, and there's a right royal dispute between the other two as between themselves. That is the holistic dispute. That dispute would not necessarily need a full trial dealing with all the expert evidence on diesel emissions and the reason for the fires and the cost of the maintenance regime. One might be able, which has happened in some of the cases that are in the bundle, one might have been able to fashion a preliminary issue with all three parties to determine the contractual matrix arguments. So that core threshold. I wasn't suggesting that what Mr. Justice Andrew Baker did would have been done better at a preliminary trial if it was only between the two of us. I still adhere to the proposition that the holistic nature of it needs to be resolved in order for justice to be done to the statute. And one of the themes I'm going to develop, I hope not to make a great meal of it because it's easily stated, is that I'm going to invite the court to be cautious about placing too much weight on the three cases that have been put to Mr. Justice Andrew Baker, which he's quoted in his judgment. Now, they're all Court of Appeal cases. Each one of them includes those with distinguished commercial experience, both at the bar and on the bench. So I'm not in any way saying I wouldn't have great respect for what is stated, but none of those establish a principle which should determine what happens on a case-by-case basis. And one has to be very careful with, for example, some of the language that's used, which is, well, UCTA might have a role to play, does have a role to play with vulnerable consumers, when what we're dealing with is better expressed in the following way. The Parliament decided, without question, that it would impose obligations on hirers, as well as on suppliers and sellers. It did that knowing that a customer, whether a purchaser or hiring something, that the customer might or might not have claims against the supplier. That wasn't a relevant factor in the statute. That's the 1973 Act. The 1977 Act says that in consumer cases, that implied term cannot be excluded, and in standard form business-to-business cases, it can be. And there is no distinction drawn between large businesses, small businesses, rich businesses, or poor businesses. So the starting point, and we're going to see it in a case which is not in your bundle, but has been put on your bench. It's a first instance judgment of Mr. Justice Christopher Clark, called Balmoral, which is referred to in Granville. It's one of the ones that's in the canon, in the bundle. And it's quite interesting because I'm going to take you to it. He actually raises the point that when we're looking at the reasonableness of exclusion, we have to start with the proposition that Parliament has imposed an obligation on the higher and limited their ability to exclude it. And that's a factor, and I would respectfully submit, rightly states, to be taken into account. And with respect to Mr. Justice Andrew Baker, it just hasn't been. And may I say this, I don't mean this at all glibly. I have great respect for Mr. Justice Andrew Baker. I'm doing a case against him which brings me before him routinely, and I do not wish to say anything which is against a judge having a judicial instinct to try and find a quick route through something rather than engage in a trial. So the idea that he was engaged in this proposition at Mr. Benz's request is not something I wish per se to criticise. But I am going to say that this was a thoroughly inappropriate case to be resolved on a summary basis. And it also resonates in this way because I'm coming off script, so in due course I'll be turning quite a few pages that I won't need to go back over. But by way of introduction, the difficulty, I don't know if your lordships will find it a difficulty, but I think it's a discomfort for the Court of Appeal. Ordinarily, in one of these cases, your lordships would be looking at an appeal in circumstances where you're being asked to decide whether the judge was right to say it was reasonable, or he should have said it was unreasonable. The problem is that I have no role to play here with the opposite and equal effect. All that's happened to me is, on a summary basis, I've been told we've got no prospect of defending their assertion that their exclusion is reasonable. I've got no role to play here to assert that their exclusion is unreasonable, because that is not, that wasn't before the judge. All I've got to show is that I've got a defence.
I think we understand.
Not who's right.
I think we understand
Yes.
the test, and I've already indicated to you that certainly my experience has been that this is not something which can readily be dealt with on a summary basis.
Well,
But can I just understand this? We have an extract from the relevant hire purchase agreement at clause at tab 11. Do we have the whole thing?
I can't remember if the whole thing was available then. I imagine that a decision was taken just to put in this page on the.
I'd really like to see the whole thing.
If it's, well, I will make inquiries to see if we can have that brought over during the course of the morning. We will
Because
have papers
what
back
strikes
today.
me is these look like standard terms and conditions.
I'm pretty sure they are standard. They are.
So
standard.
section 3 applies as well, doesn't it? Of UCTA.
Yes. I think the view was taken that between 3 and 6 it didn't matter, and that was one of the issues that's been taken in one of the previous authorities. It's not a factor that arose here.
Well, three I think is quite. Firstly, one of the things that 3 demonstrates, and insofar as it's suggested, is the Unfair Contract Terms Act is not just about consumers or primarily about consumers. It's about contract terms.
Yes.
And section 3 is not concerned with consumers. Well, they may be consumers, but it's not just consumers. And I find a certain discomfort in not having had section 3 in issue, because it seems to me this is a situation where 3(2)(b)(1) and 2 are also engaged. Because arguably, what's being said here is that we can provide you with coaches that don't work at all.
Correct. And Lord, I am going to take you back to that very point, and one of the points that emerges from Balmoral, but we can also see it in the earlier cases, which is when I walk you through them, what I'm going to call the Balmoral run of cases. We can see it in those cases as well. But what tipped the balance for Mr. Justice Christopher Clark in Balmoral, having said in one paragraph that he had great sympathy with Lord Justice Tuckett, saying he really didn't like this act intruding into commercial contracts. What tipped the balance for him was the existence of a blanket exclusion, not just a limitation or a partial exclusion, but a blanket exclusion which was capable of knocking out the core of the contract.
Yeah.
The core of the contract in Balmoral was the ability to use a product to manufacture a different product. It's a different factual matrix, but we're not concerned with that. Here, the idea that a public service coach company cannot drive its coaches around Ireland without them bursting into flames, with passengers in them, without doing something extraordinary, has to go to the core of the contract. And that's a point that Mr. Justice Andrew Baker hasn't taken account of. He's not taken account of the blanket nature of the exclusion and its effect. And we respectfully submit that that is an issue. And if it's an issue on any basis, and if it's an issue, it cannot be resolved. And it may possibly be something that you can't resolve on a preliminary issue trial, which is why I haven't said that it would be a preliminary issue, only that it might be, because you may have to decide on the precise nature of the breach, the defect, before evaluating whether it does go to the core of the contract. I'm not making that as a positive submission. It's just that I can see that being an issue before a trial judge if a trial judge was being asked to arrange a preliminary issue on contract terms only, bearing in mind the authorities which say one of the factors is always going to be, is it a blanket exclusion, and does the blanket exclusion operate at the time the contract is entered into in such a way as to negate the core purpose of the agreement. And we will see this reflected in Purnell, your lordships of the Vice-Chancellor Nichols's case. We'll then see it reflected in Balmoral, which is, I think, from recollection, 2006. So in the middle of the run of cases which are said by the respondent here to set the trend. And with respect, I'm going to make a submission that they don't really set a trend at all. They give vent to a commercial, those with a commercial background of very large cases and freedom of contract, saying that they're uneasy with it because actually, as Justice Clark called this provision protean, and I think what he was really using that expression to mean is that it's difficult to apply. And then he then went on to weigh it all up and say he thought it was very finely balanced.
Well, Mr. James, what you're doing is, before taking us to any authority, you're alluding, as though we knew it by heart, to the one you've just handed up.
I'm going to take it through.
Shall we stop previewing the cases and actually have a look at them?
Lord, entirely correct. If I could now move then to section 2, what I'd invite your lordship to do is to take up the authorities bundle.
Yes.
And we start at the back end of the authorities bundle.
Yes.
And just look at the statutes very briefly. I don't think this is going to take more than a couple of seconds. But section 10.2, that's tab 10, section 10.2 of the 1973 Act. Parliament has implied a term into every hire purchase contract stating that the goods hired will be of satisfactory quality. So I've made that point. Tab 11 is the ACTA provision. And I made the submission earlier, Lord Justice Phillips, I think has in a sense endorsed that by saying that ACTA is not a statute which is directed only towards consumers, and let alone vulnerable consumers. It applies to everybody. It applies to all contracts. So then, that's all I wanted to say about those. If we then go back to the front of that bundle, tab 1, can we pick up photo production and security? It's not a case that's going to require much of an introduction, but it is said by the friend to be part of the canon of judicial thinking, which doesn't like these kinds of interventions in commercial cases. First of all, photo production was a judgment following a trial.
Before you start on the authorities, before we leave the sections, can I just understand, you're not relying on section 3 of ACTA?
Yes, I am.
You are relying on section 3?
I am relying on section 3, yes. But it wouldn't matter if I did or I didn't, because the same point can be made under the other section.
But it's not something that was argued before the judge, was it? I mean, nobody. I don't even know whether it's accepted that these are standard terms and conditions. I don't know, Ms. Benzie.
I think it is. I'll take instruction, but I think it will be accepted.
I think it was proceeded below on the basis of them being standard terms and conditions.
Well, Lord, it is accepted that they are standard terms and conditions.
And indeed, that's reflected in Mr. St. House's evidence when he says we've got an exclusion in our standard terms and conditions, and so does every other hire purchase.
Yeah.
So
They're not only standard, but universal.
standard,
Yeah.
certainly ubiquitous.
Yes.
Yes. And that's a point they played in their aid. It seems to be, on the face of it, conventionally more of a point in favour of the customer than the hire purchase company.
Well, it's very important. I think, in terms of equality of bargaining power, because it said that these are equal bargaining parties, but that's the whole point of Section 3. If one party signs up to the other's standard terms and conditions, the party relying on standard terms and conditions has to justify their reasoning.
Well, indeed. So all I really wanted to say about photo productions and security is that it was principally concerned with the death and burial of the principle of fundamental breach, rather than anything else. So in a sense, what it went on to say is very helpful in a number of ways, but not directly on point. It was a pure common law case concerning a contract entered into before ACTA, and it did not concern the 1973 Act. So it had nothing with respect to say about the two statutes with which we are concerned. And that point is made clear by Lord Salmon at page 852, if your lordships wanted that reference. It's entirely uncontroversial. Page 852, Lord Salmon, at letter C. Lord Wilberforce did make some observations which framed the later debate. See, for example, his first supplementary observation at page 843. Perhaps your lordships could just turn that up for me very quickly. And it's going to be much quicker if I invite you to read ahead of me. Your lordships will see the Tweed letters B and C, a passage beginning the doctrine of fundamental breach. If your lordships could just read that paragraph very quickly, I would be very grateful.
Yes.
So, Lord, as I say, there are some observations there which help to frame a later debate. So I can't say that there's no reference here to the acts that we're talking about or the statutes we're talking about.
But there you can see quite starkly that the commercial matters generally, when the parties are not of unequal bargaining power, is in contrast to standard terms, because it's viewed, the whole point of it is, it's viewed that where parties are dealing on standard, one party's standard terms, they are not of equal bargaining power in that sense.
In that sense, Lord,
One party is saying this is the terms upon which we do business, take it or leave it.
And one can also see here that the use of fundamental breach had been to correct injustice. And that can be set aside because Parliament's now taken a hand. So if one starts with the proposition of what Parliament was trying to deal with, it was trying to deal with a just resolution to reliance on exclusion clauses. So I would respectfully submit that photo productions is a case which helps us if it helps anybody. So if we could then move quickly to tab 2, please. This is R&B customs brokers. And this is an obiter series of remarks from Lord Justice Dillon, in which he did say that if he'd been required to consider reasonableness, he would have found the terms exclusion reasonable, and he did so on the basis that it wasn't a consumer contract. But,
sorry, which page are you at?
well, look, there's a reference to it at page 853. And he makes his decision, obiter, on page 855, just below letter C. I'm not going to go into the detail of that. I don't think there's anything on the facts which would assist you. and life moved on, as we're about to see in the case of Purnell, that there is a later reference in a post-Purnell case about Lord Justice Dillon's remarks.
I'm sorry, for my part, I don't find the way you dealt with this case particularly helpful. I mean, can you point to the passages you're relying on?
I'm not relying on anything here. The only reason for this case being mentioned is that it crops up in the next two cases as a case relying on...
I agree, Mr. Jones, but I think precisely for that reason, we would find it helpful, if you don't mind, if you could show us which passages are later commented on.
Of course I will. If your Lordship then goes to page 855, I've referred you to the first two sentences of the paragraph just between letters C and D. If your Lordship would just read then down to the end of his judgment, that I think is the totality of the obitive remarks. If we can then move on to lease management in Purnell, which is your tab 3, I just in a nutshell tell you what this case was about. First of all, it's an appeal from following a trial. The appellate court was Vice Chancellor Nichols, Lord Justice Hurst and Lord Justice Waite. The case concerned a business-to-business photocopier contract. At the start of the judgment, and that is at page 338, the first sentence is a little unhelpful because it starts by saying this case affects consumers, but by that he does not mean consumers in the UCTA sense. It's not an UCTA consumer case, it's an UCTA business-to-business case. I think His Lordship must be meaning consumers as customers rather than consumers in the technical sense. However, it's clear that's what we said he meant. Now, he has quite a lot to say which is relevant to the current case under appeal. First of all, if I may put little headings for this, the width of the exclusion clause. The exclusion clause in our case, clause 5b, you have seen, and if you want a cross-reference for that, it's found in Mr. Justice Andrew Baker's judgment, Core Bundle, tab 7, para 69. That is identical to condition 5 in Purnell, and we find that at page 344 at letter C. that's the first passage, just that paragraph beginning before turning to the Act, tells us what the nature of that clause was. The Vice-Chancellor then made clear that he was in no doubt that that Condition 5 failed the test of reasonableness. So can we pick this up? He begins his analysis of it on page 344, just underneath where the passage I just invited you to look at. He quotes the relevant statutory provisions, and he starts between letters G and H, saying, I'm in no doubt that Condition 5 fails to satisfy the test. Condition 5 embraces virtually all liability for any shortcomings in the equipment, irrespective of seriousness and irrespective of how the warranty or condition arose. Self-evidently, it cannot be reasonable to exclude liability for breach of a warranty or condition which has been expressly given, otherwise the customer will find himself snared. He was given an express warranty which he relies on, binds himself to take the equipment, and so on. Then at the beginning of the next paragraph, importantly, he says, similarly, with the disputed term in the present case, this may be implied rather than express term, but as Canon Southwest knew, it was fundamental. Now, I'd like to explain what we think he means by that, and we need to take you to what he meant by implied rather than express and fundamental. So for this, we need to go back, please, to his page 338. And if you will please pick this up with me just above letter D, and we see this passage. In January 1987, Mr. Brothers, a commercial sales executive in the sales department of Canon Southwest, pausing there, that's the company we just see referred to in the last passage I referred on page 345. Mrs. Berry was looking for another photocopier machine. Mr. Brothers sought to interest her in a new model. This model, the new one, had a variety of new functions, such as double-sided printing. Mrs. Berry was interested, but she made clear that she would not want the new model unless it made paper plates. Mr. Brothers had no idea what Mrs. Berry was talking about. He suggested she should try the demonstration model and see for herself. She said she would try, reiterated it must make paper plates. Within a day or so, the demonstration model was installed, and she tried it out. She was delighted. The machine did everything that was claimed for it, and it made excellent paper plates. So when she saw Mr. Brothers again, she ordered the new one. Then in the next paragraph, we see what happened. The brand new 3525 was delivered. Mrs. Berry traded in her Canon 400. Then the difficulty arose. Unlike the demonstration model, the new 3525 did not produce paper plates. The ability to produce paper plates was not part of the specification, but so we are told, in practice, some machines will make paper plates and others will not. So that is the reason. There's then a complicated history as to who Mr. Brothers was working for and who he was speaking on behalf of. But in any event, it was found that there was an implied term in the contract that eventually entered into with lease management, which led his lordship on page 345 at letter B to describe the disputed case in the disputed term in the present case as implied rather than expressed.
What was the source of that implied term? Was it statute?
No, I think the source of the implied term, for my money, must be on the demonstration, because she was offered the demonstration model to see if she liked it. She said it must make paper plates. It did, and therefore I think that was carried forward as being a condition of the contract that it would then make paper plates.
So it's implied on the facts of the case?
Implied on the facts of the case, not implied by statute. But
Well, that may or may not be significant, but at least, to my mind, it may be significant that we're here, in the present case, we are dealing with the will of Parliament in enacting the 1973 Act.
Yes. Lord, my primary submission, I understand your Lord's point that it may be different, but my primary submission is that whether it's an express or an implied term makes no difference, and if it's an implied term arising from the conduct of the parties rather than something expressly stated or warranted, or whether it's an implied term imposed by Parliament, again should make no difference in principle. And the reason it makes no difference in principle is if I can take you back to page 345 of Purnell, letter B, and see what the Vice-Chancellor was driving at. He was driving not at the distinction between express and implied terms or their source. What he was driving at was that it told you in that contract what was the core, the heart of the contract, what the machine had to do in order to be compliant.
Mr. Jones, I completely understand what the case is about.
Yeah.
All I'm suggesting, and I may be wrong, is that we can't just glibly put to one side the will of Parliament in enacting the 1973 Act.
Oh, my Lord, I would very much not want you to do so. So one of my core submissions is that Parliament has decided that in 2 acts there will be an implied term in the hire purchase contract which cannot be set aside by an exclusion clause, save if the hire purchase company can vindicate the proposition that it's reasonable and so on and so forth in accordance with the 77 Act. So, and if your Lordship's saying to me that the will of Parliament may provide a stronger base for an implied term than the facts of an individual case, I wouldn't dissent from that, obviously. But it doesn't seem to me that the source of the term makes a lot of difference, because if a statutorily implied term is implied, so is an ordinarily implied term implied. I think that's. But the 2 passages I've taken you to at the top of page 345 are not there in order to drive a distinction between an express and implied terms. I don't think. I would respectfully submit that what the Vice-Chancellor was getting at was what was at the heart of the contract. I've already made the point. Here, the heart of the contract for Mrs. Berry is whether it make paper plates. The heart of the contract for us as a public service coach company is whether we can drive our coaches around safely with passengers in them. And that's a point that
You weren't buying, as I understand it, you weren't buying scrap metal. You were buying a coach that was actually supposed to drive.
Yeah.
So if there's an implied term that it has to be of satisfactory quality, that's the will of Parliament, subject to exclusion.
Yes.
Is it your case fundamentally that what you've been given is a coach that doesn't drive properly?
Yes, because it can't be driven safely.
Exactly.
And the only way it could be driven safely was in a way which was completely out with what had been sold. In other words, a coach which had to be off the road a large part of the time to have an enhanced maintenance regime which kept that proclivity to fire under control. So
I think, to put it crudely, if I may,
Of course.
to put it crudely, the case against you is, well, if you were stupid enough to contract on that basis, you're a sophisticated commercial enterprise. There's equality of bargaining power. Well, that's just tough luck.
yes, but that I think is the long and short of the case against us. But the difficulty with that is that if one approaches every commercial contract on that basis, it drives the coach and horses through the will of Parliament, because Parliament has actually directed us all to do something rather different. Protean it might be, and difficult to apply from time to time it might be, and balancing factors might be hard from time to time, but it must be wrong, I respectfully submit, in principle, for the Court of Appeal cases which the respondent relies on, to suggest that there is some sort of prevailing view that if this contract has been entered into by 2 reasonably large commercial organisations, then the starting point is that it should be reasonable for them to exclude because they know what's best.
Forgive me, I keep coming back to this, but that is an absolutely hopeless starting point when there's standard terms and conditions. That just isn't. I mean, I'd like to see whether or not that's been said in the case of standard terms and conditions. I'd be surprised if it has.
And if anything, as my Lord observed a moment ago, we need to read the passage in photo production as a whole. And what Lord Wilberforce was actually doing was contrasting the second part of that paragraph you showed us with the first part, where he mentions expressly standard terms.
Yes.
And what seems to have happened, but again, I'll be corrected if I'm wrong, is that in some of the later dicta, it's only the second half that gets cited. Is that right?
I think that's right. For me, the importance of it is to recognise that it was, as it were, signalling the death knell of fundamental breach, so be it. But it was doing so in circumstances that fundamental breach, for all its imperfections, had fulfilled a very good purpose, which statute had now taken over. So then that, as your Lordship is putting to me, frames the subsequent debate as the purpose of the statute. And I respectfully wholly agree.
Sorry.
Do you want anything more from her now?
There's a couple of things I want to go to further from Purnell. Now contrast what we've just seen in page 345 of Purnell, and can we contrast that, please, with the judgment at paragraph 21? Because it does seem to me, with respect, Justice Advocate has gone, it's fallen into error in paragraph 21. He says in 21, I'm sorry, tab 7 of core bundle, I agree with Mr. Benson that the ultimate decision in Purnell was to the effect that it was not reasonable of the finance company to seek to exclude liability for warranties as to quality relied on by the purchaser that had been given expressly by a sales agent. And it seems to me if what he means is what is said, I'm not quite sure why that would be relevant, unless it's to be in contrast to a statutorily implied term. But if he means that, with respect to him, I think he must be wrong, for the reasons that I've just explored, taking you back to page 338 to see the genesis of what the judge was saying. Say the Vice Chancellor would say. Now, there's one passage only that I would then wish to take you to further in Purnell, and that is 345. Go back to 345 if you would. And your Lordships need to read with me, or for me, if you would be so very kind, the two lines at the foot of that page. They're the ones that are highlighted. The passage at the top highlighted of the next page, A to B, and then just the first, for my purpose, just the first 6 lines under letter C, beginning with the words "I have in mind."
Well, it's very apparent, isn't it? You'd be very, very foolish to purchase goods on a hire purchase agreement if the result was you had no remedy if they were completely defective. It's really saying no more than that, is it?
Well, Lord, what he's referring to here is the trap that if you were taking a contract from a supplier, you might be protected, ordinarily would be protected. Therefore, it would become a trap if, by taking it from a hire purchase company, you were then treated somehow differently. And part of that answer is dealing with another point that is raised. It was raised in this case, but it didn't succeed in this case. So on that point, I prevail for Mr. Justice Andrew Baker, which is that the hire purchase company is reasonable to exclude liability because it doesn't have any contact with the product. And that was an argument run below. It's not. It didn't succeed below, and there's no respondents notice. And in part, what the Vice Chancellor is dealing with here is addressing that point. In other words, if that were allowed to prevail, then it would always be a trap, because you wouldn't have a contract with the supplier, you'd have a contract with the HP company, which could always reasonably exclude because it hadn't touched the goods.
But it may not touch the goods, but it contracts to buy them.
Correct.
So it can protect itself in the contract with the supplier. Correct. And it is able to do so.
Yeah.
Whereas the customer is not able to do so because they don't contract on the face of it with the supplier. They contract with the hire purchase company.
Your Lordship's, if I may say so, entirely right.
And forgive me, one thing I think is quite important here is that when you look at questions of reasonableness, one of the factors you look at is insurance. Who is it who can effectively be expected to protect themselves against this liability? Now, it isn't insurance, but surely the answer to this is the customer could not protect themselves. There's nobody they could protect themselves against unless they said to the supplier, we're only going to have these goods if you will give us some form of direct warranty, manufacturer's warranty, for example. But the hire purchase company can protect themselves. They can obtain sales warranties from EvoBus. So the answer it seems to me is that the structure of the arrangement is such that parallel with insurance, it is Dawson who can protect themselves in relation to this liability.
Dawson who can protect themselves, and EvoBus who can take product liability insurance. It couldn't fall on a purchaser, someone hiring goods, whether under a hire purchase company or sales contract makes no difference. It can't fall on the customer to take insurance against a risk that it could have no contemplation about.
Well, was there any evidence about the insurance position?
No. Another thing I was going to say, George, is that there was no evidence from either party about insurance. I'm not going to explain, hazard guess as to why that was. But there was nothing before the court about the ability of Dawson to insure, or the ability of EvoBus to insure, product liability insurance from manufacturers, importers and retailers, or anything of the kind. So none of that's before the court, and of course it wouldn't be. One of the reasons that chain of relationships wasn't before the court is because that chain of relationships was effectively excluded by the bilateral summary judgment application taken out by Dawson against the claimant, because what it did, it locked off the other two sides of the triangle from debate, and it locked off all disclosure, witness evidence from them, and all the various debates that would occur were there to be a trial directed generally to the issue. And it's one of the, we would respectfully submit, one of the shortcomings of trying to shortcut this process by a summary judgment application.
Forgive me, Mr. Jones, before we leave this judgment, at page 346, can I just ask you about the passage you asked us to read between letters C and E?
Yes.
Now, can you just help me with this? Is that passage confined to situations of hire from a finance company, which letter A was dealing with? As I read it, the passage in between C and E is a more general.
I don't think the Vice Chancellor was confining himself. Obviously, he starts by talking about the reasonableness of a condition such as condition 5.
Yes.
But I think the such as gives us the clue, and Lordship's quite right, that he was seeing this in a much more general.
I don't want to put things too crudely, but sometimes for the purpose of testing what legal principles are, it helps just to try and see if one has correctly understood what's being said here. I mean, as I understand it, what I think he's saying is that if you contract that the goods will be of a certain quality, and then, by the way, you have standard terms which in the small print say there's no liability basically for anything, that although you can discharge the burden of showing that that's a reasonable clause, that's not going to be done lightly. No. My impression is that this passage has, if I may put it this way, has a different judicial philosophy behind it from some of the other dicta which you're about to show us.
Yes.
Which basically say, well, you're all commercial entities bargaining equally with each other, so it's basically up to you what you decide, subject to very light touch review by the courts. I mean, again, forgive me if I'm putting it crudely, because I want to understand what the correct principles are.
your Lord is entirely correct to contrast the Vice-Chancellor in Purnell with some of the dictu in the later cases. They're not binding principles, they're just observations. And he is saying, and in my note, I've just looked down at my note of this passage in Purnell, is that the Vice-Chancellor was essentially saying that there may be circumstances in which you can give X with one hand and exclude liability for not giving X in the other, but it's going to be a high threshold. I entirely agree with that. Now, the other reason I've taken you to the passage at 345H and at the top of 346 is because of the framing of Mr. Justice Andrew Baker's judgment, where he's effectively taken the concept in Purnell that you wouldn't expect your rights to be different depending on which route you went down. And I've introduced this point to Lordship before, so I won't labour it, but it's clear enough from the judgment. And that passage is being, I think, used by Mr. Justice Andrew Baker to say that if I've got a claim against the manufacturer, well, fine, I'm okay. And if I haven't got a claim against the manufacturer because I didn't contract for one, or any contract they would have given me would have excluded liability, then coming back to Purnell and the Vice-Chancellor, I can't expect by the outcome to be different. And it seems to me that the obverse doesn't work. In other words, just because I've got a judgment, or if I can get a claim home against D2, doesn't mean I'm not also entitled to get one home against D1, because I'm entitled to choose, the claimant's entitled to choose its victims or get judgments against both. So
can you show us in the judgment where he deals with this?
Lord, yes, let me take you to it.
22.
Well, I think the passage I think is best is 31 and 32. So if you're going to read 31 and 32, you will need to read the 4 italicized lines immediately above, because that's the issue to which these 2 paragraphs go.
And you've alluded to the last sentence of 32 already.
Yes, I have. This is the passage that I had in mind. It might help if I just frame this for your lordships in order to say that if you go back to paragraph 26 on page 75 of this bundle, you will see the headline sentence which says, I shall consider those matters as alleged by Dawson in turn. And those are the matters in paragraph 25. And the matters in paragraph 25 are Dawson's pleaded reasons why their exclusion is reasonable. So the one I've taken you to is one of Dawson's reasons, which is pleaded and which is the learned judge was addressing in paragraphs 31 and 32. And that's the 2 italicised passages just immediately.
As the judge recognises at the end of 32, if there was a contract with EvoBus, or if there might have been a contract with EvoBus, it might have been subject to a similar exclusion clause, and that might have been considered to be unreasonable.
Yes.
I'm not sure. So that really doesn't take the matter any further forward, does it?
Well, What we respectfully submit it does not. It's not, at this stage not a relevant issue. It might be a relevant issue if we were at trial with all three sides of the triangle, and the court was considering what the correct result was in each of the contractual relationships. It seems to be, as we put in our skeleton, it seems to be deployed, as I've said, on the footing that if we've got a claim against Dawson, we're okay, and if we haven't, then we can't do better. And that, as it were, is taken as a point of principle, but it must, with respect to Mr. Justice Andrew Baker, must be wrong.
I find it's really hard to understand. If a manufacturer or a supplier of coaches supplies them and they're defective, you would think that, as against the supplier who actually does know about the vehicles and is responsible for their condition, it would be plainly unreasonable to say we have no liability whatsoever if we supply you with buses which, from the moment they come off the transporter, they don't work. And as I understand, all Purnell is saying is you can't be in a worse position against a hire purchase company because they are a hire purchase company. You as a purchaser can't be deprived of the obvious and understandable rights of a purchaser for defective goods because you purchased through a hire purchase company, and that's all he's saying.
All it's saying, but it's been, as it were, turned against us in the judgment, that it's throwing us back on the claim against the manufacturer as being the salvation. And what we would say is, it's distinct. The learned judge did press me below as to whether I would make a formal concession that were we to lose on actor reasonableness as against the manufacturer, I would concede that we would necessarily lose against the hire purchase company. And I was not prepared to make that concession. I saw the logic of what he was putting to me, and that's in the transcript, and I checked it. But I was not prepared to make the concession because it might be, the answer to that might well be fact specific. And this was an passage I was saying to you, with respect, Lord, we shouldn't be here. You're asking me to make a concession about something that hasn't happened between us and another party.
Surely that was an indication that it all ought to be tried together if the judge thought that was something he wanted from you.
Lord, I was pressing that point. It was 1:15. He said, thank you very much. I will go away and think about that. He obviously did, and I'm afraid my advocacy failed to persuade him that we were right. But we respectfully submit that we were right about that.
I'm not asking you to make a concession either. But I see the point, although you say it's a point in favour of a trial. It's difficult to see how, if there is a trial, Mr. Benzie's clients would end up in the game of pass the parcel, actually having to pay out, short of an insolvency of EvoBus. Is it too simple to say that either their exclusion is reasonable, in which case Dawson's would be as well, and you lose against everyone, or their exclusion is unreasonable, in which case they would have to indemnify Mr. Benzie's clients against any liability to you, or indeed you might get a judgment direct against them.
I entirely saw the logic of that, Lord, when Mr. Justice Andrew Baker put it to me. I just wasn't prepared to make a formal concession.
Yeah, I don't.
That logic,
You haven't got the contract between Dawson and EvoBus.
No, we've checked. We do not have it. We do not have it. It wasn't before.
So we just don't know what the terms, what their rights to an indemnity might be.
No.
They might have a cast iron right to an indemnity.
And indeed, they've said nothing. I don't wish this to sound critical. They've said nothing about that in their summary judgment pitch to the court. In other words, they've got on the basis that that's not a relevant issue, because all one's doing is looking at this in isolation, which is essentially, if we were looking, I don't take it was sort of Lord Donaldson's point about saying there's only one point in every case, but if we had to find a single point, I would say whatever else are the pros and cons of all these arguments, they're not meet for summary judgment. And they're not meet, and if they are meet for summary judgment, they're only going to be meet for summary judgment if everyone's involved and the full picture is known. That's essentially, if we want to find one single point of argument, one that I would rest on. So, Lord, that is...
Before you leave Purnell, could I just look at page 51? And the middle of the page, the Unfair Contract Terms Act.
So what you've been... I'm sorry, I've got the page in tab 3.
In tab 3, page 51, bottom right-hand corner. 344, I think, is bottom right.
I'm sorry. Right, I haven't got those paginations. 344, thank you.
This case falls within section 3 of the Act. So this was a case under section 3 on the basis it was written standard terms of business.
Not so it says, yes.
Not section 6.
So, but Lord, the generic, all the general parts of this judgment would apply to everything. It's quite right. He was looking at section 3, but we have standard terms and conditions as well. So I think it's conceded.
Did Mr. Justice Andrew Baker refer anywhere in his judgment to the fact that these were standard terms and conditions?
Expressly, I don't think he does. I think it was implicit. I will check whether it's expressed somewhere, but implicitly it was, because these terms were their terms, and the whole summary judgment pitch from Mr. Sainthouse was that they were the same as everybody else's, and you would not get better terms from them or better terms from anyone else. So that they were standard and ubiquitous.
So the Dawson relies on the terms and conditions, and you then say up to unreasonable, and you did that in a pleading.
Yes, we have responded in a reply to the defence.
Can I see that?
Of course you would. The answer is that is in this bundle, further
Tab
on.
10.
Tab 10.
So it's paragraph 9(2).
Yes.
So you have not asserted that these are standard terms and conditions, and therefore section 3 of the Act applies.
Lord, I think it was assumed by, the summary judgment was put on the basis they were standard terms and conditions. Everyone has assumed that. At this stage, we didn't plead it. But I'm going to be given a passage in the judgment which makes this. Yes, the closest we get in express terms is the judgment, page 69, paragraph 5. First sentence.
We're on Dawson's terms and conditions.
Yes.
So I know I keep coming back to it, but it seems to me it's the crucial point in this case as far as the equality of bargaining power is concerned. And it doesn't seem to have been focused on at all.
Lord, may I just press on for a moment?
Yes.
We go to Sovereign Finance, which is tab 4. This is a decision of Mr. Justice Longmore in 1997. Again, it was a trial, although a trial of a preliminary issue. I think it arose from recollection because at the start of the trial, a key witness was unwell, and he decided that he could proceed with to clear some of the contractual points as a preliminary issue, but it was a preliminary issue trial. Just by way of sketching the facts, this was a business-to-business sale where the purchaser wanted to have machinery for use in a manufacturing process. it was the same as in our case. The discussions about choice and suitability of the machine all took place, as they conventionally do, between the purchaser and the supplier. The exclusion clause was in clause 19 of the contract, and we find that at page 372 of this report. And you'll see at letter B, just underneath it, subclauses A and B of clause 19 read as follows. I think we're particularly concerned with B.
So that's about as wide as one can get.
Yes.
And it does, in terms, purport to exclude a term implied by statute.
It does.
So that would, on the facts, would this have been a Sale of Goods Act case or a Supply 1973 Act case?
This was, yes, it was a Sale of Goods Act rather than a hire purchase case. Yes.
372A. Sorry, 372A.
Yeah. We get that at page 372A, I'm told. Yes.
Yes, that's.
Supply Goods Implied Terms Act.
Oh yes, that's helpful. Thank you.
Just above. Now, if we then go to 373, can we pick up a passage, please, at E? Where Mr. Justice Longmore observes in passing that HB agreements were almost invariably made on the finance company's standard terms of business. Then he moves on to consider Schedule 2. And I think in this passage he was contrasting Schedule 2, sections 3 and 6, and concluded that he could still, regardless, look at the Schedule 2 guidelines. I did mention that earlier. There was one.
Well, he says it doesn't matter whether it's Section 3 or Section 6, doesn't it? I think it turns on the distinction.
Yeah, I think that's the burden of this particular passage, which is the one I wanted to take you to. Staying on 373, just above letter G, and over the page, it sets out the finance company's basic case. And if I could just invite your lordships to read that, because one will see echoes there of what we've got in this case, some of the issues which we referred to. One only needs to read to the fourth line at the top of the next page.
So they're really stressing they're just a finance company.
Yes. This was the point about they don't have contact with the goods, essentially. And that just didn't work. And as we will see, Mr. Justice Longmore considers himself bound to follow the Vice Chancellor. The Lordships have gone over the page. I hope I'm not missing anything out that Mr. Bensley would wish me to refer to, but if we can drop down to C, 374C, in addition, Mr. Hilton submitted that it had been open to the first defendants to finance the transaction in alternative ways, such as a direct contract of sale financed by a bank loan, that it had an opportunity to enter a transaction for the acquisition of the sheet without being subject to an exclusion clause in these terms. So we're going to come on and see there's an echo of that in this case, but in a way which we think, and with respect to Mr. Andrew Baker, defies the evidence, but I'll make that good in a moment. And then 374D, it was further submitted the first defendants should be treated as having been aware that the inclusion of such a term was a custom of the trade. So I don't think we need to worry too much about that in this particular case. Although it is said by the other side to be ubiquitous, but I'm not sure that really takes the matter very much further. So what Mr. Justice Longmore did was to follow Purnell and hold that it was not reasonable. So then we move on to tab 5. We come to a case called Danker Rentals.
Sorry, just before you leave,
Of course.
Can we just be, it may matter in any judgments that we give, that we comment on the correct passages. At page 375, Mr. Justice Longmore refers to the dicta of Lord Justice Dillon in R&B Customs.
He does.
And he says, as I understand him, that he is bound by the ratio of Purnell.
Correct.
And so he's not going to follow the obiter dicta of a single Lord Justice. That's letter D. But I just want to be absolutely clear which dicta he's referring to. I think I know, but the difficulty is that on the preceding page, at page 374, just above letter C, is the citation of RNB Customs. But it's to the weekly law reports. So it's page 322 in the weekly law reports. We were shown, I think, the All England reports at tab 2.
Yes.
That's why I pressed you earlier, if we could just be absolutely clear what the dicta are.
I'm pretty confident, though we will check over the short adjournment, that the R&B of Justice Dillon dicta is always the same passage.
Yeah, I thought so.
I will check it.
Thank you.
Mr. Roundtree can give us the cross-reference later.
Yeah, I will find that cross-reference. Yes, the decision's at 375. So if that satisfies your lordship for the moment, subject to that cross-check, which we'll promise to do, Danker Rentals, tab 5, a 1997 case. Now this was a business-to-business case. It concerned a photocopier again. The judgment followed trial, and a good deal of the case concerned alleged misrepresentations, which don't, I think, need to trouble us at all. If we go to page, and I'm using the report page numbers, page 91, at letter C.
Is this another preliminary issue case?
My note doesn't help me with that. I think it was a full trial. I think it was a full trial case. I've made a note. Not a preliminary issue. But certainly not summary. There are no summary judgment cases.
Sovereign was a preliminary issue, wasn't it?
Yes.
So if we pick it up at page 91, we see letter B, reference to Purnell, and we also see reference here to R&B Customs Brokers. And then, just below letter C, he's talking then about Mr. Justice Longmore, which is obviously not Purnell, but Sovereign. And he says, what Mr. Justice Longmore said is of persuasive rather than binding effect on this court. However, I find its logic to be powerful, and I also find its analysis is highly pertinent to the present case. The exclusion clauses here are about as far-reaching as they could be. And then, in order to pick up where this then goes, if we go over the page to page 92, please. I think for this purpose we can ignore the highlighting of the first part of the sentence. But if your lordships would just please read for me the highlighted passage first of all.
interested, Mr. Jones, you're showing us the highlighted passages at 92 in Danker, but you didn't show us the highlighted passages of Mr. Justice Longmore at 376. It seemed to me that...
Lord, I think I probably just tried to go too quickly. You're quite right.
Those seem to me to be the ratio of the case, and I'm not sure that Danker adds much to it.
I don't think it does, other than it's another one. But you're quite right. I was going too quickly. 376 highlighted passages, finishing off Mr. Justice Longmore's judgment. If I could, I don't want to label Danker rental because I don't think your Lordship's right. It's not actually adding anything, but it is part of the canon, and you may just take into account also what is said in this passage beginning with the words "of course." That's letter D on page 92. Very short paragraph. Whether there may or may not be a claim against the supplier. And then there's also another passage which could be quite interesting for the Lordship just to note, immediately opposite letter E. It's the sentence beginning "one can legitimately ask."
I'm sorry, where are you now?
I'm 92,
Yep.
letter E, and just follow one's eye along, and it's the sentence halfway through the page beginning "one can legitimately ask," just to the foot of that paragraph.
Right, thank you.
All right. We're going on then to decisions of this court.
Yes. So, Lord, then we get on to the cases that are, which three of them were put before Mr. Justice Andrew Baker by Bernard Trent as showing a trend. So let's see what they say. This was an appeal to this court from a trial in the county court. It's not a hire purchase case, but a business-to-business transport contract. So this is freight forwarding, and freight forwarding standard terms. It's not HP. The court's appellate approach to reasonableness was set out in paragraph 9, which Lordships will give you a page number, find on the report, page 986. Just that paragraph to note if you'd be good enough to do so.
Sorry, can you just give the reference again?
Of course, my lord, page 986 in the top left-hand corner, paragraph 9, and it's under the italicised heading reasonableness.
So this is an appeal from a trial, is it?
This is an appeal from trial in the county court. And to repeat, not HP, it's freight forwarding, business to business freight forwarding. Your Lordships have got down to line 7 or 8. It may then be helpful for us just to look at paragraph 10, where it says the treatment of various factors going to the question of reasonableness has been considered in a number of authorities from which the following observations of relevance emerge. And the ones that I would invite your attention to, please, would be subparagraph 2. page, depending on how fast your lordships are reading, subparagraphs 3 and 4 as well.
Right. Thank you.
And just to note, subparagraph 8 as well. There are often or occasionally clauses not in hire purchase contracts, but occasionally in some contracts, clauses which allow an option.
But that's not the case here.
No, it's not the case here. In a sense, that's a positive point for us that it was never an option on standard terms, because it may be something then pointing to reasonableness. One sees the way in which this then ends up, because Lord Justice Potter decides at the end, paragraph 22, page 992, the county court judge had given a careful judgment in which he considered and weighed the various considerations, which was not open to any substantial criticism. Therefore, he dismissed the appeal. So I was not able to divine from this authority anything which assists your Lordship's court or Mr. Justice Andrew Baker as to the approach that he would need to take. If I'm missing something of critical importance in this case, no doubt Mr. Benzie will take it to you, but it doesn't seem to me that it gives you any assistance at all. If we then go to Watford Electronics, which is tab 7, this followed, just to get the basics, a preliminary issue trial. It was a limit of liability clause and not a full exclusion clause. And your Lordships will see the clause at paragraph 6. We can then go to paragraph 14. It tells us what issue went to the Court of Appeal. 14, right at the foot of 14, subparagraph little 7. It's not a subparagraph, it's just a list. It says the clauses 7.3 and 10.6 of the relevant terms were unreasonable in their entirety under the Acts of 1967 and 77. Can I demystify two things? First of all, 7.3 and 10.6 are said elsewhere to be in identical terms, so one doesn't need to search for the other one. The 1967 Act is a reference, obviously, to the Misrepresentation Act, with which we are not concerned. So there was an implied term in a sale of goods case. It's not a hire purchase case. Now, if we look at paragraph 21, the Court of Appeal noted that the judge had found the limitation to be unreasonable. We then go to the Court of Appeal's judgment at paragraph 31. I'm going to pick it up in line 4, if I may. It seems to me, says the Lord Justice, it's necessary to determine first the scope and effect of that term as a matter of construction. In particular, it's necessary to identify the nature of the liability which the term is seeking to exclude or restrict. whether or not a contract term satisfies the requirement of reasonableness within the meaning of section 11 of our term does not fall to be determined in isolation, but falls to be determined where a person is seeking to rely upon the term in order to exclude or restrict his liability in some context to which the earlier provisions of the 1977 Act apply. Missing out the reference to 1967. We then go to paragraph 39. We see here that there is a reference in paragraph 39 to a case which isn't separately before you, called E.A. Grimstead. And I just want to point out a passage in the second quotation for Grimstead on the next page. And that says, at halfway down, second, it is reasonable to assume. About line 10. Second, it's reasonable to assume that the price to be paid reflects the commercial risk which each party, or more usually the purchaser, is willing to accept. The risk is determined at part at least by the warranties which the vendor is prepared to give. The tighter the warranties, the less the risk, and in principle at least, the greater the price the vendor will require, which the purchaser will be required to pay. It is legitimate and commercially desirable that both parties should be able to measure the risk and agree the price on the basis of the warranties which have been given and accepted. So that is obviously not a hire purchase case, but it forms the background to what was then decided, part of the background to what was decided in this particular case. If we could then go over, please, to the next page, to paragraph 42, where it says, this court should not substitute its own view of what is fair and reasonable for that of the judge unless satisfied the judge proceeded upon so erroneous principle, or was plain and obviously wrong. I'm satisfied the judge fell into error in three respects, that those errors do vitiate his conclusion. So we then see those three ways in paragraphs 43, 45 and 48. I'm not going to ask your lordships to read all of them, but if you could just read the start of 43, the first 5 or 6 lines, I think that will give you sufficient information.
Mr. Jones, when cases, even in the old days before Bailey and so forth, were unreported and remain so 20 years on, it's usually because they didn't say anything that was terribly innovative or binding or is more than obvious. What do we get from this case that is not sort of law of contract, course 101?
I would respectfully submit that your lordship gets nothing from this case, and neither should Mr. Justice Andrew Baker have got anything from it. I'm dealing with it only because it was deployed by the respondent, and it figures in the judgment. Lord, I respectfully...
Which is the passage on which Miss...
Well, the particular reliance is on paragraph 55. And when your lordships have read that, I'll then just take you back to one short passage in 54.
Was this a standard terms case?
Yes.
Yes, I think it was.
Section 3.
Recollection.
Yeah, so section 3 is considered.
What I want to say about paragraph 55 is with respect to this. I would commend to this court that it is not part of the ratio, because the ratio is the assessment of factors set out in 54. Yeah. It's in the nature of an observation that if, with respect to the Lord Justice, it was intended to be more than that, it must, I would respectfully submit, be unsound. That was not a submission I could make for Mr. Justice Andrew Baker. I think I can say it here. And the reason I respectfully submit that it's difficult for the court to approach the question of reasonableness on the basis that it is for the parties to have made that judgment is because that, I'm afraid, looks as if it's starting to defy the statute or the statutes taken together, where regardless of the size of the organisations or the sophistication of the organisations, the contract will have a term applied into it, and that term cannot be set aside unless it complies with certain conditions. Let's call it the reasonableness condition for the moment, taking account of the non-exhaustive list in Schedule 2. But it couldn't possibly be right that all one does is to identify these two parties as being of a certain category, whatever that category is and how one defines it, and says that they are now in effect responsible for making the reasonableness decision. And I would very respectfully submit that there is if what is being said is that these Court of Appeal authorities, and paragraph 55 is one of them, is establishing a trend of judicial thinking as to how these statutes are to be applied, I would respectfully submit that it's not a trend which should commend itself to this court unless you were to consider yourself bound by it as part of the ratio.
Well, Mr. Jones, speaking for myself only, I'm having difficulty at the moment understanding how this passage applies in the context of standard terms. Where the court says in about the 5th or 6th line of paragraph 55 that the court should not assume that either is likely to commit his company to an agreement which he thinks includes unreasonable terms. Well, if you're dealing with a commercial organisation which says, here are my standard terms, take it or leave it, I just don't understand how that sentence applies.
Well, Lord, I would respectfully agree. Perhaps I could see an argument to the opposite effect if I was playing my own devil's advocate.
Yes.
To the effect that it would be open to a sophisticated party to read standard terms and say, I think they're fair. It's possible that someone might stand in a witness box, although it's unlikely.
No, I can see that.
And make that point.
I can see that. And of course, the UCTA doesn't say standard terms are simply struck down. It
Correct.
says that they can be reasonable, but it depends on the facts, and it depends on whether the burden imposed on the defendant is discharged.
Yes, and one looks at a whole panoply of points. Whether it's a blanket exclusion or a partial, whether it's a limit, what could it exclude? Could it exclude the very thing that's being sold in reality, and so on and so forth? I wish to choose my words carefully, but I would venture to submit that paragraph 55 should prove of no assistance to the lordship's court.
Then we have to read paragraph 56, which I think helps us to understand it. Because it says, 55 says, where experienced businessmen representing substantial companies of equal bargaining power negotiate an agreement. And 56 says, in the present case, the parties did negotiate as to the price. Mr. Jesser secured substantial concessions on price. The parties negotiated also as to which of them should bear the risk or the cost of insurance against the risk of making good the loss of profits and the other indirect or consequential loss which Watford might suffer. And that was the issue that the clause went to, as I understand it, indirect or consequential loss.
Well, may I respectfully agree that if one's looking for the decision, we find the decision in 56 based on the factors in 54, I would venture to submit that even if one was looking at the factors found in 56, 55 does tend to go too far in suggesting that there might be a trend of surrendering, essentially, prima facie at any rate, the decision to the sophisticated parties. If all it's saying is that if we're faced with a line-by-line negotiated document, both parties with independent advice and so on and so forth who sign up to it, well, that's obviously a powerful factor for the court to take into account.
I mean, if the clauses have been individually negotiated, then it's not a standard term.
It would not be. Absolutely not. I wish to move on from this in a way because I'm doing my best to assist the court, but 55 is not our argument, but it is in the judgment. The learned judge was asked to look at these three cases, at the passages picked out, and he has quoted them. And I would venture to submit that he's not, I think it is beyond doubt that he's been persuaded to an extent, influenced perhaps I should say, by them. And I'm going to come on in a moment and say why that is so, because his judgment actually quotes a passage from one of them. And in fact, we can do that now, because your lordship's looking at paragraph 55. And what we see in the judgment, where this is referred to, let me find it. Yes, if you go to paragraph 37, that's bundle page 79. I'm going to come back to this if I have time, but this is his lordship's summary of Dawson's primary argument.
Well, up to you, Mr. Jones. You've been in the game long enough. But what I suggest you might want to do is either complete the series of Court of Appeal references and then go to Mr. Justice Andrew Baker's judgment and fire shots at it.
If your lordship's making a note, we'll see the wording at the foot of paragraph 55 when we get to paragraph 37 of the judgment.
All right. Well, should we do that? I think you've got one more Court of Appeal case to come.
One more, Lord Justice Tuckey.
Well, let's do that and then go to the judgment.
So this is the third of them. Sorry, 2000. There's 2003 case. This one. The last one is Lord Justice Coulson in 2018.
Right.
So so this again, to get the basics right, is a Court of Appeal decision following a trial. It is another British International Freight Association standard terms case. The issue concerns 30 subsection B, and we can see that quoted in paragraph 1. And you will see immediately that this is a time limit agreement, in other words, a contractual limitation period than would occur under the Limitation Act. Very different type of case.
Again, preliminary issues.
I think a trial of preliminary issues, but it was certainly not summarily determined.
Yeah, paragraph 4.
Now, if we then go to paragraph 15, excuse me. I'm sorry, I'm just being asked to point out to you, relevant provisions of the Act were set out in paragraph 5, and that did include section 3. If we look at paragraph 15, I think it's an inescapable conclusion from what he said that the judge did think that the clause applied to a claim of fraud and to a claim to be fraudulently concealed. The judge was not asked to construe the clause so widely, and I do not think such construction was justified. So this seems to have, the judge's decision has been questioned then on the basis of his construction of the clause. It says the clause is obviously designed to meet ordinary contractual claims such as those made in this case, which a straightforward would expect to have. So that's the trigger, as it were, for then the Court of Appeal considering the matter afresh. They started to do that in paragraph 19, where the learned Lord Justice referred to the Schedule 2 guidelines. Then if we go over the page, please, to 23, we see a short passage which I'd like you to read whilst I continue talking. The simple question is 9 months a reasonable time? And he says, I have no doubt that it is for a loss of or damage to goods in transit, because the loss or damage can be ascertained on delivery. So that's what the case was about. Actually, a fairly limited point, and very difficult to see that it has any resonance with ours. So then we move to the highlighted passage at 31. And if I could just invite your lordships to read that, because that's the passage that was brought to the attention of the judge. And one can't help noticing here that a factor in that passage, which I would respectfully submit renders this of no value to our particular case at all, was that this was a mixed contract with 3 elements to it, 2 of which were specifically excluded from the Act, and only 1 fell within it. One can't help thinking that Lord Justice Tuckey thought that was an unfortunate result, that he should even be considering the Act in those circumstances. But I would respectfully submit there is nothing here which is of a trend, and nothing here which says that this or any court should approach the task Parliament has asked it to undertake by making, as it were, some sort of prima facie assumption that there is a certain class of contracting parties who theoretically fall within the Act, but who are assumed to have come to a decent contract unless someone can prove the opposite. And in a sense, it's beginning to feel here almost as if one's going to be assisted by that passage, the burden of proof, which is built into UCTA, is being turned on its head. I'm not suggesting Lord Justice Tuckey had that in mind at all, but if one's not careful, one could begin to sense that sort of issue. So then could we go, please, to look at a case which is referred to in this, and could we look, this has been handed up to you this morning.
Balmoral.
Balmoral.
Right.
Well, this judgment is 177 pages long. We haven't troubled you with 177 pages.
Very glad to hear it. It's referred to in the final case.
It's referred to
Lord Justice Tourismo.
In good life. So, can I invite you to pick this up with me, please? Page 118. So we see the Act being referred to. This is the 1977 Act, so this is UCTA. It doesn't mention subsection 10.2, so it's only for this purpose dealing with 13, 14 or 15 of the 1979 Act. Nothing, I don't think anything turns on that distinction. So could we go please to paragraph 398, page 121. The effect of the Borealis conditions is that if Borealis deliver borosine, which is the product they were selling, which is either of unsatisfactory quality or not reasonably fit for the purpose which was required, Balmoral has no redress, beyond at best the possibility of a replacement of the defective product or the return of its price. Is that a term which is fair and reasonable to have included in the contract? Over the page, 399, Balmoral submits that it is not. It is, they suggest, neither fair nor reasonable for Borealis to include in the contract terms which exclude liability for breach of the core obligations of satisfactory quality and fitness for purpose, with the result that Borealis escapes any real responsibility for the unfitness of borosine for its purpose, which has caused Balmoral foreseeable loss on a massive scale. So Lord, this reflects what we've already seen about in Purnell and elsewhere, about going to the core, the heart of the contract, whether you can give with one hand and take away with the other. Borealis' submissions, paragraph 400. Borealis, which has the onus of proof of reasonableness, points out that this case concerns major commercial companies, not consumers. Although Borealis is a much bigger concern than Balmoral, Balmoral is a company with a turnover of over 30 million a year. Paragraph 401, and I only want to look at the first 6 lines or so. They also rely on the difference of position between themselves and Balmoral. Borealis produces raw materials with a wide range of uses and applications across the world. Borealis can and does perform a number of standard tests on samples of its product, but Borealis cannot be expected to test it for all uses of any prospective purchaser. So there was a purchase of specific point there. If we go over the page to page, paragraph 403, please. The rival contentions of the parties raise in stark form the question whether a major supplier of raw material can, where ACTA applies, successfully avoid liability other than for the price of the goods or the replacement for breach of the conditions ordinarily implied into the Act. There is then a reference to Granville, which we have just seen. That's Lord Justice Tucker's passage. The freight forwarder, going up underneath that, the freight forwarder in that case was held entitled to rely upon a term requiring suit to be commenced within 9 months of the occurrence of the cause of action. In this case, Justice Christopher Clark clearly looks at the guidelines. He says this: I share Lord Justice Tucker's reduction in enthusiasm, not least because of the difficulty of applying so protean a concept as that of fairness and reasonableness in a context where the application of these criteria may produce different results according to whether they're looked at from the point of view of the buyer or seller. Nonetheless, he then went on to consider the guidelines. He talked in 407 about the strength of the parties' bargaining position. So far as the terms of contract are concerned, Borealis would not knowingly have supplied borosine other than on its terms or terms to equivalent effect, unless they'd been persuaded to do so for some very good reason. If Balmoral had raised with Borealis the question of supplying borosine on Balmoral's terms, they would in all probability tell that borosine was not available on those terms. As Mr. Cartwright put it, it would have walked away the moment the proposal was suggested. So, in a sense, standard terms in all but name, I think, is what Justice Christopher Clark was saying there. 408, Balmoral was a large volume purchaser which was able to and did negotiate actively on price. So it wasn't able to negotiate on terms, but it was able to negotiate on price. The possibility of Balmoral switching supplier, as it did, was always a factor tending to keep the price down. So 409, the solution to that is, so in relation to price, the parties were on at least an equal footing. Or indeed, Balmoral may even have had slightly the upper hand, but on terms, they were not. Para 411, lest it be relevant to your lordships, given one of the issues Mr. Justice Andrew Baker dealt with, line 4, Balmoral personnel knew, or at least ought to have known, that the price quoted was on the basis that Borealis' terms applied. If they wanted to know what Borealis' terms said and meant, they only had to read and consider them if necessary. Para 412, line 2, line 1, we'll start there. Material consideration, already, albeit not one reflected in the guidelines, is the reality of the customer's consent. As to that, Balmoral didn't pay too much attention to the terms upon which they were ordering. We know in this case...
Mr. Jones, sorry to interrupt.
Of course.
I'm getting a little concerned about time. It's 25 to 1. We'd obviously like you to finish at the lunch break. You've got this case, Lord Justice Coulson's case, and then you're going back to the judgment. But don't leave yourself just 2 or 3 minutes to go back to the judgment.
I think I can catch. Your Lordship's quite right, and I have been looking at the clock, but I think I can catch up. But I've made a lot of the comments that I want to make along the way.
All right.
So, Lord, perhaps I can pass on through 412 because I don't think it's relevant. 413. Another material consideration is the damage that would be suffered if the borosine provided should be unfit for purpose. That's the core of the argument case that we want to put. Can we go over 2 pages, please? Conclusion. We pick this up in 418. I regard the question as to whether or not Borealis' terms satisfy the test of reasonableness is quite finely balanced. In the end, Borealis had not satisfied me that their conditions satisfied that requirement. And perhaps if we just go down to 422, a determination of the reasonableness of a contract exclusion requires consideration of whether the allocation of risk affected by the exclusion is appropriate. I've not been persuaded that requiring Balmoral to bear the entire risk of a latent defect in the product is an appropriate allocation of risk. The Sale of Goods Act itself recognises that, all other things being equal, it should be the seller who bears the responsibility, and that's a point I've made earlier.
Yes.
And so what we have here is that point reliance on the statute and also the centrality of the defect, the core of the contract. So very finally then, good life.
You might want to know 423 specifically pointed out that Watford was a case where there was serious negotiation as to the instance of risk.
Yes. Well, in a sense, the court should not likely treat such agreements as unreasonable. That I think is a nod to Lord Justice Tucker's point, which is already addressed. But he then goes on, nonetheless, to hold that this one was unreasonable.
Yes.
So,
can you help me? What was the nature of this hearing?
Forgive me, let me just. I think that was. Oh, it was undoubtedly a trial. It was a full trial, not a preliminary trial.
You'd think so.
Well, yes, you
400 and something paragraphs.
The first.
All right. Well, we'll assume it was. If it
We will
wasn't,
check.
It also lasted from January to March.
Yes.
Yes. it was, and the first 2 pages of the judgment,
That's a
just
trial.
the index of everything that followed. So
All right. Let's go on to good life.
Lord Justice Coulson, good life. This was an appeal following a preliminary issue trial, and we get that from paragraph 3. The clause in this case was held not to be the same as a blanket clause, and we get that from paragraph 45. The judgment then reviewed the common law position in photo production, Granville and Watford, and we get that in paragraphs 61, 62 and 63. I'm not going to invite your lordships to read the highlighted passages. You've already read them in the source material.
Yes.
Again, they're not our highlighted passages. The next section of the judgment talks about the importance of insurance, and you see that between paragraphs 63 and 64, which we know is absent from this summary case. Then we get over to page 69, and we see a reference to Balmoral. And I don't think you ask you to read all of 69, just to note that it was taken into account. Paragraph 70, as Lordship said, in my view, 3 points should be made about that part of the judgment in Balmoral. First, the assumptions made by the judge meant that, as a matter of fact, the supply of a product with a latent defect made the manufacture of satisfactory tax impossible. On that assumption, it was perhaps unsurprising that a clause excluding liability was found to be at odds with the assumptions at the heart of the contract. So we would respectfully submit that this demonstrates that this judicial trend isn't a judicial trend at all. It's kind of rather an ephemeral trend, because here it's actually reflecting on the facts of the case. So Lord Justice Coulson is in no way critical of the Balmoral decision. In fact, he endorses it. And he endorses it for reasons which we would respectfully submit are reflected in our position. He then goes, Lord Justice Coulson then goes on, paragraph 73, to start with the Schedule 2 guidelines. But I don't think it's necessary for me to go through them, other than to say he's just going through them on a fact-specific basis in relation to his case. And then at paragraph 79, importantly, if you go down, please, with me about 5 or 6 lines, there's a paragraph, a sentence starting, "This is an important consideration." It is unreasonable for one party to exclude liability for the vast majority of the damage and loss that might arise from its own defective performance, whilst making clear that if the customers want such liability to be excluded, then on taking out of and payment for the necessary insurance liability would be accepted. For the reasons I have given, I consider the answer is no. So what is relevant there is that there was an option in the contract. In other words, the customer could have had the cheaper price or the more expensive price, if you like. And answering that question, Lord Justice Dawson came to that decision. If we then move on to the next highlighted passage, which we get at 89, I'm not going to spend any time with this, I'm going to leave it to Mr. Benson, but I'll just say that the Lordship has it here. It's 89 to 94. But I would respectfully submit that your Lordships will find nothing there which is at odds with anything that we have been saying. And it certainly doesn't support the sort of trend of judicial thinking which has imbued Mr. Justice Andrew Baker's judgment. So Lord, I will now turn to what I want to say, and I will do my best not to repeat what I've said, but I do want to say some things about the judge. If I have told your Lordship of an exchange between Mr. Justice Andrew Baker and me during the hearing, and I've explained what happened during that, your Lordships have wanted to see that transcript. You will find it at Supplemental Bundle, tab 3, page 87. I'm not anxious to go through it as all transcripts. It goes back and forth, but there is that reference if your Lordship wants it.
Can you give me the reference again? I'm sorry.
Yes, of course. It's Supplemental Bundle, tab 3, page 87. Have I got the tab number right? I think I have. Let me just check. Yes, I have. And there's a few pages that follow it, if your Lordship was interested to follow it. This was me being pressed essentially on whether I would make the concession in advance of the full trial, which I declined to do. But I was trying to get across the point that I hope I've made here, that we ought to be looking at this in something of a vacuum. Now, the judge came back to this in our submission in his paragraphs 31 and 32. We've already looked at this very briefly. I have taken you to these paragraphs, so I don't think I need to take you back to them. I've made the submissions I want to make here. But I would respectfully submit that the only logic behind these two paragraphs, if it gives an insight into the judge's thinking, is that if C's got a remedy against D2, then it's reasonable for D1 to exclude. And if C doesn't have a remedy against D2, then it could never have a better remedy against D1. That is the logic that I think is behind 31 and 32. I may be wrong about that. I'd like to think I am, but with respect, that's where I think that has gone wrong. And if I were to say why it's an unhelpful passage, is because it ignores Purnell, and the page and passage in Purnell is Purnell page 346, where the Vice-Chancellor said the customer would not expect his rights regarding defects to differ according to which of the two acquisition routes he chooses. Is that those authorities, properly understood, do nothing more That authority is nothing more than that. Now, Mr. Justice Andrew Baker undertook 5 exercises in his judgment, which are central to the appeal. In paragraphs 25 to 34, he analysed Dawson's pleading, which was put forward to support their assertion that it had the benefit of a reasonable and enforceable exclusion clause, 25 to 34. Then he analysed the Schedule 2 factors in paragraph 35. He then provided what looks to be his own list of what he considered to be Dawson's primary case at paragraph 37. He had earlier rejected their reliance on their lack of connection with the goods, and he said at paragraph 39, reflecting that they didn't need that point. But I would wish to make it clear that I respectfully submit it wasn't open to them in any event. Now, he then went on in that paragraph 39 to say there was only one factor going the other way. And that, with respect, is far too simple for all the reasons that have emerged during the course of this hearing. Now, if we go back to 37.1, there's a point I need to make good here. Because in 37.1, the judge says Lost Bus was a substantial commercial entity, well able to acquire the Tourismos if it so wished, without contracting on a hire purchase basis with Dawson. With respect to the learned judge, there is no evidence to support that finding, and I respectfully submit that it wasn't open to him, summarily or not.
Can you say exactly which aspect of that finding are you referring to?
It's without, they could, if they so wished, have purchased the Tourismos without contracting on an HP basis. Now, the only support for that in the evidence is found in paragraph 28, little 3 of this judgment. Which refers to the reply. So let me see what Mr. Justice Andrew Baker said. However, Last Bus wasn't obliged to use hire purchase finance at all. It was free to be a cash buyer. Last Bus has pleaded that it could never have paid cash for the Tourismos. That plea is obviously unsustainable. It is contradicted by an admission in the next sentence that Last Bus might have been able to finance the purchase by bank lending, in which case it would have been a cash buyer. Now, that is said to be, and is, the sole basis upon which the finding that they could have done so emerges in the subsequent paragraph. And if your lordships would be good enough just very quickly to look at the reply with me, it's in the same bundle, tab 10, paragraph 12.4. Could I just ask you to read that paragraph through?
I think your main point is the last one, is so what, even if you're right.
Yeah, well, there is a so what point, but there is, I think, an error in the finding here, on a summary judgment. It's a little bit unfortunate. So it's a little bit unfair to judge to say the plea is obviously unsustainable, that they couldn't pay cash because it's contradicted. Clause 12.4 makes clear that if they were able to borrow the money, they would then have paid cash. The question is whether it was open to the judge to say on that pleading, with no evidence and no exploration of any evidence and no evidence from any bank, not looking at their accounts and what they could borrow and so on and so forth, none of that, was it open to the judge to make the conclusion he comes to in order to support the primary argument, paragraph 37.1, upon which we've lost? The answer is, with the greatest of respect, that was not open to him. It's got to be answered in the negative. Now, don't need that sole basis upon which we appeal, obviously. But it's right that I take this point because the evidential basis for the assertion that this was Dawson's primary argument, one of the first of three, it is, I would respectfully submit, wrongly premised. And after a summary hearing of that nature, unfairly premised. 37.2 comes back to the Purnell point, reflected in a number of the subsequent judgments we see. If Last Bus was not content with the exclusionary terms, it was in a position to secure contractual assurances so as to qualify as to quality as EvoBus was willing to offer, either alongside the HP or, if necessary, by buying directly. So this comes back to the other part of the triangular model. What is being assumed against me is that either I could or I couldn't, but it makes no difference. So this is a summary judgment hearing, a judgment which effectively says that it is possible to look at the reasonableness of the hire purchase company's exclusion completely in a vacuum, because nothing else can affect the result. And with respect, we say that's wrong. And then he puts in 37.3. Now, what of course he hasn't done, I don't blame him for this, it would be strange if he did. What he hasn't done is to assess what the answer may be if one or two of the three primary arguments were to fall away. But I would venture to submit that if that was the position, then we would have one.
I must say, I find some difficulty in the course of dealing argument, because the very first contract that was entered into would have been subject to the test of reasonableness. And let's assume it was found to be unreasonable. Well, the fact then that you enter into another contract on terms which are also unreasonable, does that, or had previously been unreasonable, does that now make them reasonable?
Well, I don't see how it could. I don't see how it could. What it would be suggesting is that if you enter into one contract with an unreasonable term, it doesn't bind you. If you enter into a second contract with the same unreasonable term, it does bind you, or possibly after 3 or 4. But if the first one doesn't bind you, it's very difficult to see how that, without more.
Well, in a sense, it's a matter of legal analysis. You didn't enter into it with that term because it was void.
As a matter of, your lordship's quite right. But the difficulty would be, I suppose there could be facts where somebody said, on contract 5, you do understand there's condition 5 in here, and so on and so forth. So it could evolve, but taken in a complete vacuum, it's very difficult to see how 39.3 really helps. Can I make one other, give me criticism of the judgment, which I think is, again, a little unfair. The paragraphs 25 to 34 are the paragraphs where the judge sets out Dawson's pleaded case as to why their term is reasonable. So that's what they should be relying on. And if you'll go to tab, in the judgment tab, page 77, we've looked at paragraphs 31 and 32, could we now look at paragraph 33? The italics below 33, the italics at the bottom is the issue. The transaction for the acquisition of the Tourismos by Last Bus was structured contractually as it was because Last Bus and EvoBus, being very experienced in the commercial passenger vehicle market, knew and understood that Dawson would exclude all liability for defects and that no reasonable financial provider would accept such liability. Consequently, Last Bus required the protection of contractual provisions as to fitness and suitability in the contracts with EvoBus. Now, can we go over the page and see how the judge has dealt with that? This will be highly contentious and will require a trial if it is to be pursued as pleaded. Pausing there was no suggestion that it was not to be pursued. I wonder if it is more forensic flourish than serious factual plea. So, it then goes on to say it fails to grapple with a point, but it seems, with respect, rather unfair to accept jurisdiction to consider a specific list of points pleaded in support of reasonableness, to find that one of them is highly contentious and will require a trial, which in the ordinary course of events would lead to one and one only result. But we find there that the judge has, as it were, decided not in argument, not as a matter of submission, not because he pressed Mr. Benzie on it and Mr. Benzie said, yes, we'll be dropping all that. But the judge himself has downgraded all those arguments to concentrate on three. And I may be wrong, but I don't recall those being put forward as the primary arguments, but there it is. That's what Justice Ankerberger had extracted from the case. But on the face of it, there is one which, on his own judgment, requires a trial, but is then ignored. 37.1 has no warrant in the evidence, with respect. 2 ignores Purnell, and 3 suffers from the point that Lord Justice Phillips has just put to me, that 30 wrongs don't make a right. If the first one didn't have a valid exclusion clause in it, then neither did the second, and so on and so forth. So then when we get to 39, we find the balancing act is therefore taking place not only in summary form, but on a, with great respect, an imperfect basis. And all I have to do for this purpose is to knock out or question any one or more of 39, and the decision goes. Now, because this is a summary judgment, it would be very difficult, in my respectful submission, for your lordships to say, having concluded that the judge has fallen into error, that you will continue to treat it as a summary case and you will replace it with your own independent judgment. It seems to be that the odds, because that's what you would be doing if it came to you from a trial, but it hasn't. So my respectful submission is that for all the reasons of principle that I've tried to headline as I've gone through the argument this morning, through the hearing, but also these specific ones tied into the text of the judgment. This judgment is, with the greatest of respect, one that we are entitled to impugn. And sadly, the appeal, sadly for everyone, in a sense, because we've lost time and traction, but sadly, the appeal should succeed, we respectfully submit, and this matter should be remitted back for trial, with all the points being investigated that have been discussed during the course of this hearing. Lord, I've taken about 20 minutes longer than I had intended. I'm sorry about that.
Thank you very much,
I've
Mr.
answered all
Jones.
your questions.
Any questions? Thank you very much.
I'm very, very grateful. Thank you.
Mr. Roundtree.
I'm told we do have 2 of the documents your lordship was asking for. And let me see if I've got this right. We've got. Yep. So we've got the full terms as between us and EvoBus, and the terms between us and Dawson. But what we haven't got is the terms between Dawson and EvoBus. And I've also got some additional pleading materials left. So that's the part 20 pleading is here as well, if your lordship wants it. I don't know if you want to see that now, but you asked, it may well be that you don't need to see it, but if you do, we found that much at least.
We were in principle willing to have copies of any of these, but you better show them to Mr. Benzie first, and you can reflect on over the lunch break about whether we need to see all of that or whatever, and make arrangements for copying.
Lord, let me make my position clear. I'm content to rest without them. Lord Justice Phillips said he wanted to see them. We found them. I have not brought them at this stage in order to sandbag Mr. Benzie, and if he's unhappy about it, I'll let him make his own submission.
Well, it's a bit odd, if you don't mind me saying, it's a little bit odd to be considering the reasonableness of contractual terms without having the contract. And what I would expect to see is at least have sight of, is the are the terms and conditions, but also presumably there is a schedule or a statement of the specific contract in question.
I will check what's there with Mr. Benzie and see what we can hand up.
All at the moment we've got
It's the offending clause.
is the clause,
Yeah.
and I feel a little uncomfortable
I understand.
at not seeing the contract we're being asked to consider in its entirety.
All I can say on behalf of both sides, I think, is that we had made a determined effort to reduce the amount of
Yeah,
paper. I'm sorry if that.
I understand exactly why you've done it, and that
Yes.
may well be that it adds nothing, but I just find it helps one to get one's bearings to actually see. I mean, for instance, I don't understand at the moment what the terms of this hire contract agreement were, hire purchase agreement were, or its nature, because there are different types of hire purchase agreements. And I haven't yet understood what type this is.
I understand. Lord, we've done a good job in keeping the bundle small, but we've done too good a job, I think, is your Lordship's message, and we will do our best to remedy that over the shortest journey.
Yesterday we were given a case with a supplementary bundle of 1,147 pages, about 1,100 of which were no use at all. So we're very happy you should in that direction. But see what you can do over the afternoon.
Thank you very much indeed.
Well, Lord, I was only going to rise to say, that the Part 20 pleadings will address the issue that Lord Justice Phillips raised about the contract terms between Dawson's and EvoBus.
Oh, well, that. Then, speaking for myself, I would certainly like to see those. Hopefully they won't run to hundreds of pages.
They don't.
What else you need, we leave you to work out.
You set out in that your contractual claim against EvoBus.
I haven't looked at it recently, but I know the contractual terms are pleaded in there. There is a battle of the forms between EvoBus and Dawson's on rival terms between the two. So it may, how far it takes you.
Well, that would be a matter for trial.
Well, I'll come back to that after lunch.
Yes. Right. 2 o'clock.
Court rise is able.